Howdy, and welcome back to You've Got People Problems, the podcast where we tackle the leadership challenges that no one wants to talk about, but every business faces. I'm your host, Mel Ortiz with Activate Human Capital Group. Today's conversation is with Sheila Carroll. You'll hear more about her experience as we get into the episode, but what stands out most is her expertise in employment law and how business leaders can protect themselves from litigation risks, especially in those tough moments when layoffs or terminations are necessary. In this episode, we'll cover proactive and responsive strategies for minimizing litigation risks when terminating employees, why honesty and documentation matter so much, and where well-meaning leaders often go wrong. We'll talk about key distinctions between individual terminations and broader layoffs with new California regulations that you need to know, why less is more in exit conversations, and why kindness, done the right way, actually protects your business. And lastly, practical steps for documentations, the importance of severance waivers, and preparing for PAGA or class action pitfalls. So let's get to it. Howdy y'all, and welcome to this episode of You've Got People Problems. I'm so excited to jump in today because the guest I have is Sheila Carroll, and the conversation we're going to have is around minimizing litigation risks in a layoff. And really, when I think about layoffs for our audience, so often it's a person that needs to be terminated, but we're also going to cover, because there are some new laws around layoffs specifically, we're going to go down that rabbit trail a little bit. And Sheila is the founder and majority shareholder of a boutique law firm around helping businesses deal with employment law, deal with specific, kind of act as in-house counsel. Is that right, Sheila?
That's right. Yeah, we're a general business law firm, which means we help people with their governance, their corporate governance. We help them with litigation having to do with business. But running any business these days has a lot to do with employment. And about a third of our book of business has to do with advising or defending employers in employee-related actions or issues. There's a lot going on with employment right now.
There's a lot going on with employment. Mostly employers are trying to run away, especially in California where we are, trying to run away from having employees of any kind. So can we get them out of state? Can we get them offshore? Can we just automate them? And turns out there are some jobs we need done.
Right. No matter what, some of them are going to be here, right? And workforces are here to stay. And we need those people. And there's a lot to be said for culture and having people around too. Although I do understand the need from PAGA and class actions for employers to want to flee. So I know you work with employers to help them have a better workforce, and that's great. And in spite of all your good work, there are probably some bad eggs now and then, or employees who need to be dealt with. Yeah, and dealt with harsh. So.
I think we're going to have a very interesting and timely conversation since there's so much going on in the world of employment law. And I'm hoping that you can help listeners think about both proactive ways to protect themselves, responsive ways if they find themselves in a situation where a termination needs to happen. And we can navigate this together. If you're listening because you know Sheila and not me, my name is Mel Ortiz, and I'm all about talent optimization. So how do we get the right butts in the right seats that fit from an aptitude perspective so that they can get to a high level of performance quickly? How do we engage them, and how do we keep them so that they know how to win at work every day and they're engaged in their job? So I'm looking forward to this conversation. So tell me, Sheila, a little bit about, as we think about mitigating litigation risks as we terminate individual employees. Let's go there first, and then we'll get to groups of employees because there are some specific rules we have to follow there. But what I see more often than not coming across my desk is someone who's not performing. An employer feels like they've tried everything they can think of to get this person up to a level of performance that's acceptable, but we're not there. Where does it go wrong that costs employers time, money, and heartache that maybe we could do a better job of preventing?
Right. Well, after someone has worked with someone like you, who is probably, well, I know in the case of using you exactly, that they're going to know that documentation of poor performance is necessary. And then there's some motivation things I'm sure you can do as well, and meeting milestones. But that doesn't always work. And there's a time when employees need to separate from an employer, right? And it's up to the employer usually to make that happen. it's a lucky day when those people just quit. That doesn't always happen, right? So what's the right thing to do? Interestingly enough, when dealing with an employee and giving them notice that they're not going to be working with you anymore, it's really important to be respectful. And I know that sounds really basic. And of course, the people we work with are professionals and are going to be respectful. But let's kind of break that down and talk about what that has to deal with. Not being dishonest is a big issue. And by not being dishonest, that doesn't mean that you need to peel the onion again and tell the person every single thing they've ever done wrong. Not at all. But it means that if they're being let go, you're telling them they're being let go. If it's part of a reorganization, it's fine to say that. If it's part of a layoff, it's fine to say that. But if you're making up that layoff or that organization in an effort to be kind, that's not really kind, and it's probably not going to fly. And by not going to fly, I mean the employee will probably realize and maybe even pay attention to the workforce after they leave. They may see ads on LinkedIn. They may talk to their friends. They may realize that you hired someone right away in their place. So why is that a layoff? And suddenly they think you're being dishonest. So, and although it was a kindness, it is a form of dishonesty, right? Which is a form of disrespect. So once it's dishonest, they start to get suspicious. So is it against the law to tell a social lie? No, it's not. But it can create a look of suspicion for that employee to think about, why are you really letting me go? Is it because I'm part of a protected class? Is it because I'm over 40? Is it because I'm brown? Is it because I told you I have this medical condition? Suddenly the employee thinks it's about something else. And if that something else happens to be a protected class meaning a reason you can't terminate somebody for, then they might glom onto that. These days in the world of billboard plaintiffs' attorneys, usually when someone loses a job, it's very common to Google something like, I just lost my job. And then an AI tool or even Google results themselves or search engine results themselves will give them any list of lawyers with chat boxes saying, did you lose your job? I'd like to talk to you. There are even billboards that say, lost your job, sue your employer. All kinds of things that are really obvious, and kind of nasty. So by not being candid with someone, you can end up in that situation where you have a lawsuit. And hopefully I'm not going on and on and on too much, but once you're in front of that plaintiff's lawyer and you've been terminated and many people don't want to admit or maybe don't even realize that they were not meeting those criteria they needed to meet, the employment plaintiff's attorney is going to ask them a bunch of questions. How old are you? Do you have any medical conditions? Are you in a protected class? Have you ever talked about your religion at work? Any number of situations suddenly are blown from an employee who wasn't performing to an employee who is now maybe not making up, but truly believing that you let her go because of her mental illness disorder that she mentioned to you once. So
because we didn't say absolutely clearly, you're late every single day. That is not acceptable. Now your job is over. Because we didn't say, you've made multiple mistakes that cost us a lot of money. We are now at a point where we cannot tolerate this anymore. So then they fill in the gaps with reasons that it can create real problems for their employers. Is that what I'm hearing you say?
That's what I'm saying. It's even safer, not safe, it's safer than telling a story to say, I have to let you go, and even not giving a reason. Now, if they're face to face with you, you probably should give a reason, as you said. Otherwise, there's such a mystery that it could lead to a problem. There's no legal obligation, though, to give a reason. And often in the documentation, I advise not to give a reason. Certainly in the conversation, I give a reason. But in writing, it's just your last day of work is going to be May 30th. Your final paycheck has been enclosed, and just the bare facts. Please return your fob and your ID badge. Pretty basic. That also allows, if there is litigation later, that gives you room for, if you discover other reasons after they've been terminated, post-termination, that they should have been gone, that will help you. So
the Really, the distinction I'm hearing is the difference between a layoff or a reorganization and an actual you individually are being terminated, not a
Yes.
group or role.
Right.
That's a distinction, a simplicity of this is over, you're out.
Right. Right. Now, if you have a legitimate reorganization, and we'll talk first about small reorganizations, not a whole division. We'll talk about those large scales later because there are new rules in California. Let's say you're getting rid of, I'm seeing this in the Bay Area right now. Some of the smaller startups are just really downsizing their marketing departments. So, which sounds kind of short-sighted because how are they going to get business? But okay. Anyways, so marketing is just all of a sudden going away from 20 people down to 17 people, right? So that actually is a reorg. A bunch of people are being let go. They're not going to be rehired anytime soon. That employee isn't going to hear from the other employees, hey, 5 other people were hired, so that then it is kind and appropriate to tell somebody, hey, this is part of a reorg, we're going a different direction and we're just going to narrow down and use some offshore or use some out of state or whatever they think they're going to be doing at that point, right? So that's a different story because it's honest. And it just looks suspicious if you say you're being laid off when you're not. And I hear that story a lot. So I try to keep people from going into that narrative that's so well intended. I mean, it's meant to be kind, but I liked your approach too. It's like, look, Sylvia, you've been late 5 or 6 times in the last 3 months. We've talked to you about this repeatedly. It looks like you might be a better fit somewhere else. This workplace isn't going to work. Yeah. There's a better way to go. Right?
There's less confusion and less mystery around it, I think. And one of my favorite quotes is, to be unclear is to be unkind.
Yes, and I agree. I agree.
It's eternally frustrating because I don't know any entrepreneurs who vindictively want to get rid of people. They gnash their teeth about, should I feel responsible for them, and they've got a mother that's sick that they've been taking care of, and I kind of understand why they're late, but it's affecting our productivity. And they just go on, and it's, I get it. They want to take care of people, but at what cost is usually the conversation.
Right. And it's a big cost, right? And at some point, you do have to let people go. And it's very difficult, but there's, honesty and directness. And I realize that I wasn't giving all the candor in the written letter, and verbally, if someone says why, then yes, I give some of those reasons why. It's just not going to work out. And tardiness is the biggest issue, but we've talked about several things, and because of you working with these businesses, there are things they've been told about before, right? Coming out of the dark, although it's not illegal, can be a little scarier, right? And by the dark, I mean getting rid of somebody without documentation can be a problem.
Certainly not best practice.
It's not. There are times when something egregious could happen, but that should be written up that one time at least and in the file. And that's probably, hopefully, in the handbook that you hopefully have. Yeah. It says we reserve the right to terminate in egregious circumstances. So somebody reacts outrageously at work, screaming at other coworkers, doing something unsafe, that you can analyze it from that angle as well. And I usually try to get to safety as a reason.
So I want to go down that rabbit hole a little bit in terms of coming out of the dark. What have you seen with clients, or what have you heard them say that they do to get their notes out? Because so often employers and managers have these frustrations and they'll verbalize them to each other, but they don't get documented anywhere. Have you seen anything you're like, oh, that was smart, about the way they get these somewhere that can be used for their benefit later if it comes to needing to defend themselves?
So the most common thing I see that's helpful is one supervisor will write to another and say, Steve came in late again today. This is the 4th time, or a note to HR. So you've got it documented at least that way. That way, you're not pulling down a separate write-up form. I tell people, use their phone and do a little audio recording in their notes. Do something. Texting is helping and hurting us. So it helps us when you have an employee using a phone that is hopefully partially reimbursed, right? Because they're using their private phone or on a company phone, texting and saying, I'm going to be late, I'm going to be late, I'm going to be late, I'm going to be late. And that gives a better history than an oral phone call used to, right? Because then someone would have to say the purpose of the call. Texting helps, but there's another side to texting too. If you pull the records and find out that that employer was always texting the person after 5 to ask a question and doing other things.
It all becomes, is it the word discoverable, where it's like, oh, if we're going to open this can of worms, let's open it all the way up.
That's right. Unfortunately, if you're producing documents having to do with a termination, you can't really pick and choose, and you're going to have a whole stream of things. So it does create a nice record, though, if you're really clean about when you communicate with your employee. And even then, I do a small reimbursement for tech every month to most employees, and I recommend that. It doesn't have to be much. It can be $10 or $15, but otherwise they're using their private phone and not being reimbursed, and that's another claim that you don't want to deal with. Not to get off track, but
well, that's a great tip, though, right? If it costs us, I don't know, a couple $100 a month to keep that protection and acknowledge there are very few employees I know that don't use their personal cell phone for work at some point. So there's a bit of an acknowledgement that's kind of like today, and maybe you get some flexibility benefits out of that, but
right,
protect us as employers. That's interesting.
And a lot of us have our wage and hour systems, right? So our log in and log off and break times are done with phones. So if I have someone using a personal phone, I want to reimburse for that. It doesn't have to be a lot, maybe $10 a month. Most people have phones these days. If someone doesn't have a phone, then you give them a device to log on with. It happens in some workplaces where someone doesn't have a phone.
I mean, I'll say on the farm, our irrigators have as good a technology as I do on my phone. It's kind of baffling to me, but that's a priority for them, especially the younger ones. The older ones, I think, generally still have flip phones, so they're a little less.
Right. Well, when you think about it, it's the way you do everything, right?
It is. They don't want to be left out. A lot of them are here from Mexico on a H-2A worker visa, and they want to connect and stay in touch, and it's an easy way for them to do that without a lot of infrastructure.
That's right. So going back to that termination thread, if we go back up to the top. So respectful, of course. Also, kindness. So you don't want to, kindness, again, there's a balance, but often when an employer gets rid of an employee because of the teeth gnashing, everything else you've talked about, by the time that employer gets rid of that employee, they've had it, right? So often that employee will run off to the employee development department to collect benefits, right? So they want to get benefits because they've been terminated. And a lot of employers will say, no, you've been terminated for cause. I'm not going to give you benefits. Well, that does two things. One, the right to unemployment benefits is really broad. And that's because, the employee pays into that too. So the employee is usually entitled to those unless they have stolen, punched somebody, just really done something egregious at work. It has to be. So
that's a fight we generally shouldn't fight, is what I'm hearing you say.
Okay. Right. And even trying to fight it, if you win, that employee is then so mad that then they really do start to Google that plaintiff's attorney again, right? And they're everywhere. Try it sometime. Try Googling "my boss is mean." You'll get a lot of chat boxes. And in Orange County and LA, big billboards. So, and they're on the signature line by opposing counsel, those billboards.
So I'm an employer. I'm frustrated. I feel like I've done everything I can to get this employee up to par. Now I'm going to terminate them. What does kindness really look like? Is it just holding back? Is it a tone of voice? Where do they go wrong in that space?
So I'd say the way to do it is you're being honest, you're being direct, but you're not overtly being mean. So it's really kind of bland and boring. So, Scott, I'm picking a lot of names, people I know. These are no real people, I promise. Names of friends and acquaintances. So Scott comes into my office and, we have an appointed meeting time, or maybe he's even on a Zoom. We'll talk about that in a minute. But he comes into my office and I say, it's time that we have to part ways. Here's your exit package. We can talk about what we want to put in that in a moment, but here's your exit package and you no longer work here. And I'm sad to say this, but we're at a point where it has to happen. And then if Scott says why, and say, well, we've talked about this before. You've had a few write-ups that very specifically address it. And try to leave it there. It's really hard to have some silence. If you have write-ups, they're going to speak for themselves. Some of us chat a lot when we're nervous, right? And if you start talking too much about it, I know your mom's been sick, but you can't keep showing up late, right? And then it's suddenly you're talking about mom and this whole other issue, and that wasn't your intention. Your intention is I've written you up a number of times for things having to do with tardiness, and it's just not working anymore. We can't run our business without you in place. And that's generally enough. And then be quiet. And mind you, from Steve's perspective, or did I say Scott? This one's Scott. Scott's got a storm of thoughts going on in his head. He wants to know how to pay his rent and feed his kids, and he's worried. He may not say much then. So silence works pretty well. And then telling him next steps. Sometimes they even tell people, of course, you can apply for unemployment benefits. Your last paycheck is enclosed, because it should be, the time you terminate someone, right? Your vacation time has been paid. If you have any questions after you leave, reach out to HR, reach out to me. I don't always say that last sentence, but I find if I do, it's a little softer. If you're trying to be soft, say if you have a question, you can reach out, because we shouldn't bar anyone from questions. What if there's a mistake calculating something in payroll? You want to know that, right?
Yes,
so
we can fix
basic and try to keep it brief.
That's one I've heard, especially like the more tactical HR people, since that is not my space, comp, benefits, and handbooks, say a lot. It's just less is more, because a lot of us get more chatty as we get nervous, and we feel bad, and we've done all the gnashing of teeth. And so the less is more, and then the transition after a little bit of silence to, okay, here are the next steps. Here are your options. Here is your exit package. Here's what we've done and your final check, so that we're answering some of the questions they should be asking, but maybe are too flustered to do. And it helps move the conversation past this being an open door of whether you do or do not work here anymore.
Right. And there will sometimes be the scramble of, is there anything I can do? It's like, I'm sorry, this is the final decision. Unless there is something they can do, but usually there isn't by the time you get there, because you probably already had a meeting about the last thing. I also recommend I'd say this is mandatory. Someone else needs to be in the room. So whether it's in person or a Zoom room, someone else should be present, because things are heard a couple different ways. Now on Zoom, a lot of meetings are recorded, and that's a benefit, right? At least it should be a benefit if you're speaking just on those exact points that you want to stick to, right? But it's good to have someone else get there. If you're concerned that someone might be angry, it's really important to have someone else there, with that phone in hand. That isn't quite as frequent an occurrence, but I do have people who are sometimes concerned that someone will get angry or violent or something, especially if there's a behavior problem involved, like physical behavior.
We talked about having somebody on Zoom. It opens up a whole host of challenges if we are terminating someone not in person, which so many employers now are having to face. Tell us a little bit about how do we make sure a final check is delivered, all the exit paperwork. How are you seeing that dealt with effectively in meeting all the requirements legally?
It's really tough, because it's not exactly a surprise anymore. Because a Zoom termination, which at the beginning of the pandemic was unheard of. I don't know if you recall, I recall when Stitch Fix did it, and everybody thought it was so cruel and so mean and so unreasonable. And I'll reserve judgment on that. But these days, that employee may not come in every day, or maybe not at all. It could be a completely remote relationship. So you have to do it this way. So the ugly reality is what an employee sees is a meeting on their calendar, and they probably notice someone from HR is coming, or another person, and their boss, or maybe they're not told another person's there, but they're going to see it. And then there's a FedEx package that arrived, at 10 a.m. as well. So, or you can have that check depending on where you live or how accurate, like what time you can get FedEx to deliver. You could have something come by 5 o'clock, and maybe you have the meeting and then the check is delivered later that day. That will work, but you want to do same day. If, heaven forbid, you use a courier and that courier doesn't get it till the next day, be it a mail courier or an in-person courier, then pay that 1-day penalty, send that extra check and get it over there. So you don't have a problem on that level with the Department of Labor for late wages, right? So get the payment. And so people often know, and this is something I see on LinkedIn again, is from the employee perspective, you're going to be laid off or fired when you get that mysterious calendar invite, right? And you get a creepy package or a notification that you're getting a FedEx later today. That's the other thing. Even if the FedEx or UPS or whatever it is scheduled to be delivered later in the day, a lot of us can see on our devices when something is expected to appear. So people know. So they might have more questions. So, okay, that's fine. Just be ready think of it as office gossip that leads someone to know that they're going to be let go. It's just happening differently. But it used to happen in a big office because maybe accounting cut the check and accounting was a little loose on telling someone the check was cut. It's the same thing, really.
It's a different methodology. I know. It's okay. There's another thing that I've heard in the entrepreneurial circles about if we offer a severance, there's something we can ask for in return that mitigates some of our exposure. How does that look from your perspective? And is there any truth to it?
One of my favorite words, waiver, right? So you want to get a release and a waiver if you're giving someone a severance. A severance, in my opinion, shouldn't be unilateral. I offer severance in exchange for a release. Now, there are limitations these days on a release, and it gets a little complicated. You're not going to get a release of unpaid wages completely unless there's a dispute on those wages. But that's really a technicality, right? Because you're going to give this person this last paycheck, and that letter is going to say, let me know if you have any questions, right? So someone
Sure.
should be getting back to you. That should help. Yes, and unless we're talking about a performance layoff as opposed to something else. There
Sure.
are things that can't be waived, like your ability to testify about harassment and other things, but those are nuances. Generally, always get a release. I often recommend if you have someone, if you can afford it, and most employers can't afford not to, if you have someone leaving, even if it's for a fairly harmless reason, like, oh, I'm going off to veterinarian school, or I'm going to stay home and help my mom because she's ill, I still try to get a release and give someone 1 week pay, because then I have a release. Because often after people leave, they start to think about other things and reasons and why they really left. And there's so much in the media about employers being mean and employers being difficult and dishonest. Employers are really painted as evil creatures lately. And because of that, a release is a nice thing to have, and then you don't have to worry, especially if you have that employee who just was problematic and then suddenly they're giving up. They might decide that you had a problem with them. And a big sneaky problem I'm seeing lately, not sneaky, it probably sneaks up on everybody, is in the mental health space. If somebody says they're stressed out and then later they're diagnosed with depression, and now suddenly you're accused of dismissing someone for a disability that you didn't know about, right? Because it doesn't always come out. So that's tough too.
What words of wisdom do you have in that case?
So keep a really good employment file and make sure that your managers are communicating with HR. So we talked about that email, right?
Yeah.
For documentation. So I want my managers, the ones who are on the ground, feet on the ground, talking to the employees. I want those people to report what's going on with their employees. So if someone calls and says, hey, I'm really kind of depressed today, I'm going to take a day off, and that never gets to HR, that type of thing that can show up in a lawsuit later, that this person told the manager that they were upset, had just gone to mom's funeral, just needed a few days off, but it never really gets recorded anywhere, then that person is being disciplined for showing up late, oversleeping, all kinds of things that no one thinks about that being a depression diagnosis because we're not physicians, we don't diagnose that, right? But I've seen that on more than one occasion in the last 5 years. Again, this was sort of a pandemic start for a problem. I'd seen that type of issue come up where someone is having a tardiness problem and then it's later linked to depression, which can be real. It can also be pretextual from an employee. But if a manager is told and doesn't move that up, then it's not going to be in the personnel file. Because what I want to look at, if someone comes to me about a termination and has questions, or if they're making their own, an employer is making his or her own decision on whether or not to terminate someone, they should look at that personnel file to see if there's anything in it they need to be worried about. Has that person complained about harassment, even if you resolved it and it's all okay now? Has that person had a question about their wages? Same thing, even if it was a misunderstanding, it's been fixed. Like, hey, I thought I'd get overtime on this day and I didn't, and it's all been fixed and we all think it's fine. If someone is terminated close in time after activity like that, it can be construed as retaliatory. And
here we are thinking we're just closing open loops. We're responding to questions, and the obligation of a bunch of FYI emails just goes
right. It's just a matter of, you just fixed it. Somebody said, hey, I missed an hour of overtime. I wasn't paid, or I didn't get to take my break. And the employer fixes it because they know how to do that, right? Because everybody is educated on this now. We know how to deal with it. But still, it's like, oh, that was retaliatory. And I don't want to make employees sound bad. I have been blessed with a ton of great employees, and I interact with wonderful employees all over the place. Most employees are just great and want to perform well, but some are not and will either make up a story directly or just not believe it's possible they did anything wrong, and therefore they have to brew a story later. And
So let's talk a little bit about broader layoffs. If there is if I'm going to close a location or do something like that, that's all. There's changed legislation this year in California. There's been some level of legislation nationally. What's going on that people should be aware of today?
Right. So Worker Adjustment Notification Act, it's a really old act on the federal level. It's 30, 40 years old. It's been around a long time. And it was intended for a plant closure. So in Detroit, right, an automotive manufacturer closes a whole plant. And the idea was if a lot of members in our community are being laid off, we need to know that and give them some resources. So on this big federal level, a rule went out that said you've got to give 60 days notice in those instances, right? And there were some other rules to go along with that. And that's been around a long time. And the general criteria has been if more than 50 people in a workplace of more than 75 people, more than 50 people at a time in a location, or even a bunch of buildings that, are attached or very close in service area. If 50 people are laid off at a time over a 90-day period, then you need to give this 60 days notice. And you're paying people during that time, assuming they're showing up to work. Some people just stop showing up to work, but you're giving them notice. And the purpose of that is so they can go find another job so it doesn't harm the community, right? So because of more layoffs in the state of California, there's now a CalWARN Act that's newer, and it's a Senate bill. It's Senate Bill 617, and it went into effect January 1, 2026. And now there are greater notification rules, and they're a little different than the Federal WARN Act, and maybe what you wouldn't expect unless you talked to a lawyer or looked it up or knew about them. So you have to give this 60 days notice, right? Additionally, you have to tell people about a workforce assistance program, either provide one yourself or give them the name and email and phone number of one, like SETA is one, Sacramento Area Employment Commission. That helps too. So you have to tell them. The other thing is you have to give them a link to CalFresh, which is the food bank, right, statewide. And I can see how shocking this would be for an employee to receive too. I understand they're trying to give notice, but an employee is receiving this and they're thinking, wow, they're telling me where food banks are. This employer doesn't think I'm going to find a job. So it's well-intentioned, but probably makes it kind of scary for an employee. Right. But the idea is to get people back in the workforce, but it places a pretty heavy burden on the employer. And there are a lot of really detailed little nuances, like maybe you had laid off 30 people and 30 days go by and it's like things are still bad. So you lay off another 10 and then another 10 and suddenly you're 50 and you didn't know it in 90 days. Doesn't matter. Like, so the moral there is if you're getting rid of even a chunk, do the notice properly, right? Yeah, do the notice conservatively, I mean, and just give the 60 days, which is hard because you're now paying people, you're giving them notice of 60 days. People don't work as hard once they've been given notice, right?
And they turn their attention to what's next rather than what's in front of them. So that
they have to find a new job, right?
Issues that we're fearful of.
So it's burdensome, it's hard, but it's a requirement. It's something legal to think of. It comes up though when an employer sells a business or merges with another business and a bunch of positions are eliminated. And part of a good buy-sell agreement, something we do on our business side of the business, right? Purchase and sale agreement. Part of that would be allocating whose responsibility it's going to be to take care of those notices and those employees. So, you sell your business, think it's a liquidation event, done, you're happy, and suddenly you're in trouble. And what trouble looks like is you can get sued in a class action or a PAGA case, and the first bit of damages, other than the other things that can be named, would be 60 days back pay. For 50 employees, that can be a whole lot of money, right? Yeah, so that's kind of a tragedy. So it's an interesting law, super well-intentioned, but a little sticky. And I'm wondering what's happening with tariffs, and layoffs. There are some exceptions, and one of them is war. So I'm wondering how far the war exception is going to be stretched if someone's related to the petroleum industry. We'll see.
Sure. Interesting. We didn't really touch on PAGA. Is there anything any notes of caution or encouragement you'd like to offer related to the worms?
Encouragement. Encouragement's a hard one. Stay in touch with your legislators and keep encouraging them to reform PAGA. There are efforts every year, but the reform didn't really give us very much. There are some things. Here's some words of encouragement. The last reform, which came out, I think it was 2023, 2024, said that if you do an audit before you've been charged with any allegations of not having paid someone properly, and these are often, PAGA can be used for any number of private attorney general action issues, but most often they're used for missing breaks, missing lunches, or overtime. Those are the most common ones I think see the most expensive.
So these are wage and hour issues.
Right. So if you have an audit of those things done, and the statute isn't very clear on what that audit has to have, but if you hire someone to come in and look at how you're paying people and take a sample of all of their paychecks and see how everyone's being paid, and if you've got some corrections that need to be made and you make those corrections, or if you can get a report that there are no corrections necessary, that provides a little bit of a defense on the penalties if you're sued later. Doesn't get rid of the wages though. And then the biggest problem with that statute is attorney's fees. So if you have a wage and hour problem that's costing 50, 100, maybe even 200,000 in missed breaks, missed lunches, that's one thing. But to get there, there's a employment attorney on the other side who's got several $100,000 worth of fees that they expect to get. So that adds up really quickly. So if you have a PAGA matter, You want to get in as fast as you can and figure out if there were really any missing problems and get that information to the other side where you fixed it and fix it as soon as you can. There are a lot of early PAGA mediations I'm seeing, and this is really uncomfortable because they start with opposing counsel, in my case, the plaintiff's attorneys, wanting all the payroll records for all locations. But on top of that, they want all the financial information of the business, or if it's a small business, the key owners. And they don't even want to talk unless they see that financial data, unless you say that finances aren't going to be a defense. Because often for a small company, $700,000 is going to break them, right? And they can't pay that type of settlement. So if you have financials to show that's real, that will help you. If not, it won't. So that's a scary way to go into mediation. It's a new trend, and I'm hoping somehow that turns. I'm hoping something is done with the fees. We're not there yet, but.
Are there industries that are more at risk? I mean, I think about our family farm, right? You've got a guy on a tractor and he's at the wrong end of the field to take his lunch break because his lunch is in his pickup at the other end of a 100-acre block.
Absolutely. There are a lot of industries that are more at risk. Certainly, farm labor, construction labor, restaurants can be iffy. Just anywhere where it's hard for someone to take their break is going to be an issue, but there are practices that could be put into place, and a lot of that is really telling people at every, the morning meeting. Sometimes you have a morning safety meeting or at least a weekly safety meeting, right? Telling everybody what our practices are, what we're going to do, reminding everyone to take those breaks, looking at the timesheets from time to time.
It helps if you mean it.
What?
It helps if you mean it. Like, I really do want you to take a lunch.
Well, that's what I was going to look at. Look at take a look at those timesheets. If the breaks are always exactly on the same minute every day, they're not real. And you know that. So then you have to say, look, I really want you to track breaks. Here's a tool to do that. And then something that I always want to say is, if you missed a break, let me know. We're going to pay you. Right? If you miss a break, you're going to get an extra hour paid. And we're going to give you that break anyways. So if you miss your breaks, let me know. Did anyone miss breaks today? Did anyone miss breaks last week? And you have to mean it. And meaning it means when you hear one's missed, you pay. If you ask someone to save 5 minutes overtime, this happens in law firms all the time with hourly workers. You've got a statutory deadline and you want to get something out the door and you're asking your assistant to just work one more half hour. You should also be sending an email saying, please make sure to add your overtime, and then check with HR and say, hey, did Colin get his overtime? He stayed late today. So again, it's more communication, something else to do. But employees are entitled to wages, period. So it's your job as the employer to make sure that happens. And you have to ask a lot.
Yeah.
So.
This is a very dizzying space to be in. And all we're trying to do as business owners is just do good work for our clients and customers to earn a living. And I think so many employees don't realize what self-imposed manic depression entrepreneurship is. And yet that's not their problem. It's just not. And so I'm grateful to have somebody like you in my network. I know you've had clients for 20 years. You've also have new clients. My family is among those. And I'm grateful to you for your time, Sheila. There's so much wisdom that's been imparted. And I think going back to just the kindness and respect and the sincerity of following the intent of the law, that people are entitled to be paid, and we should make a concerted effort to make sure that they can go a long way to them giving us the benefit of the doubt when termination time comes, when hopefully a layoff doesn't come, but they can. And I really appreciate the wisdom and the heart that you put into your work, Sheila, because it really does matter on both sides, the employer and the employee.
Thank you so much. I appreciate the time, and it's been a wonderful conversation. So thanks for all the great questions. I'm thankful for what you do. It makes workforces better and easier to work with.
So if people would like to contact you, how would you like them to reach out, Sheila?
Best way to reach out is email, which is my first initial, my last name, and it's scarroll@thecarrollfirm.com, or you can always just call the office, which is 916-488-5388.
Thank you so much for your time. I hope you join us on another episode of You've Got People Problems.
Absolutely. I've enjoyed listening. All right.
Okay.
Take care.
Well, that's a wrap on this episode of You've Got People Problems. If you got something out of the conversation, make sure to subscribe, leave us a review, and share it with the other leaders in your network, because let's face it, we all have people problems. You can watch full episodes on YouTube or listen on your favorite podcast app. But either way, thanks for listening, and we'll see you next time.